Hi, I'm Beth Gantz. I'm a business coach at the SBDC, and I'm joined today with Chris Corpus from Corpus Law Inc. for our Let's Chat about some LLC questions that we often get from our clients. So I thought it'd be great, Chris, to get together and and chat about that. Chris is a small business lawyer who helps many of our clients, is a friend of the SBDC, and we're always so grateful for all of your expertise and support. So if you want to tell people a little bit about you, Chris, and then I'm going to start to ask you some questions.
Sure. Yeah, thank you. No, I've worked with the SBDs and their coaches for a long time, and it's always and so yeah, I have my own law firm, Corpus Law Inc. It's actually just upstairs in the Desich building, the same building as the SBDC is located in. Very convenient, and I help clients with business matters, corporate matters, commercial real estate, and trademarks. So, yeah. And that's why it generally is a pretty good fit, because your clients generally have questions within those areas. So
exactly, and you're always so helpful to give your time for a few minutes to answer some basic questions, and we so appreciate that. But lately we've been getting questions about LLCs, not necessarily creating an LLC, but what happens if I'm in a partnership in an LLC and I want to dissolve it? What happens if I have an LLC, but I want to start another part of my business? Do I need another LLC? We get the question about doing business as in Ohio, which you can touch more on, that we don't have that designation in Ohio, but what does that mean? So I just wanted to talk about some of that stuff with you, just to clear some things up and, get some information about those topics. So let's start with the partnership. I know oftentimes people will want to start an LLC partnership. They have a friend, a family member, something like that. And then maybe something doesn't work out, or they want to move on, or the partner wants to move on. And they think that I can just take them off the partnership. But what does that look like? And what are some things to think about when going into a partnership?
Yeah. So, if you have a limited liability, so probably the first thing is back in about February of 2022, Ohio updated its limited liability company law. And the prior limited liability company law was Chapter 1705 of the Ohio Revised Code. We are now using Chapter 1706 of the Ohio Revised Code. And the big issue is, it's not just that we have a new law going forward, it's that the old law has been repealed. So if you have an operating agreement that makes a reference to Chapter 1705 or something to that effect, that's going to be it's going to be it's a non-enforceable provision in your operating agreement, because that whole chapter of the law does not exist anymore. So you do want to go back through and look at your operating agreement. More than likely it needs to be updated, because it was a pretty substantial update in the law. To make sure you comply with the new chapter 1706, and there's a lot of other new options that you have. So then the question is, what happens if you have a limited liability company with more than one member? So you have a multi-member limited liability company, and one of the members, it sounds like more than likely it's a cordial split. Both members, it's not, they're not fighting. One member has maybe moved and is no longer involved in the business. Maybe their life has changed and they got a different job. So it's an amicable split. And so what should happen is the member that is going to be leaving the company, their ownership interest should be redeemed. So you should have a redemption agreement that specifically sets forth, on this particular day, they are no longer a member, all their membership interest has been redeemed. And then what's the compensation or consideration that's getting paid? Is it just $1? Your business, it really isn't making any money, or is there truly some value there that in the redemption of this person's ownership, they should get paid some amount of money, and whether it's in one lump sum or if it's over a series of months or years that they're going to get paid this. But the worst thing that can happen is, effective December 31st, 2022, you are no longer a member. Yep, we both agreed to it. We had coffee and we talked about it. And then in 2023, the company hits it. They get their big client, and all of a sudden now they've quadrupled their earnings, and the other member goes, oh yeah, we haven't signed any paperwork. I'm still a member. I get half of this. And so that's the thing that you don't want to have happen. And so for the most part, every business wants clarity, and they want, knowledge of, certainty of what's going forward. And that's where that redemption agreement comes in. It very clearly says this person's no longer a member, who the remaining members are, and what consideration is going to get paid. So I always recommend, that person formally be redeemed.
And is that something they can write on their own, or do they need a lawyer to help them write that?
In general, you get what you pay for.
Right.
So you can do it on your own. Sure, you can probably just do about anything on your own.
Okay.
But then the question is, do you know what you're doing and what the different provisions are? And that's what you're paying for, that knowledge from the attorney to make sure it's done correctly.
We highly recommend working with a small business lawyer. It's definitely worth the nominal fee, really, at the end of the day, to save you a lot of headaches later. So
I agree with that. I had a client that, they drafted their own agreement. It was a relatively a very negotiated document back and forth. Neither side had a lawyer, and it just was inartfully worded. And they've spent probably 6, 7, 8, or 9, or 10 times in legal fees just trying, and they don't even have a resolution, just trying to figure out what they agreed to in this very vague language, than they would have spent if they would have just hired an attorney on the front end. Normally, there is a cost up front, but you're doing it to buy your peace and going forward. So it's usually, like you said, well worth it.
Yeah, definitely. So another area, as I mentioned, that we get asked a lot about are you have an LLC and you want to start another part of your business. And oftentimes I will say that it does relate to the business they're currently in, but they want to name it something else. So we'll be asked, do I need another LLC? Can I do doing business as? What does that mean in Ohio? So what is a recommendation for that type of client who may, want to have like a wholesale and retail side or something, but they want their wholesale name to be different, maybe, or something like that, but it's still related to their business. Now, we do have some people who are like, I have a restaurant and now I want to be like a marketing consultant, right? And that is not always, that maybe needs 2 separate LLCs. That I don't know though. So yeah.
So it could be any situation where you're expanding and you're not just creating existing, additional capacity for your existing business. You're not just hiring another employee. You're opening a second restaurant. You are, like you mentioned, you're doing retail and you're going to do wholesale, or you're going to offer ancillary services. So you do have multiple options. One of those would be you set up your limited liability company, just call it Corpus Holdings LLC. And then underneath that limited liability company, you just want to do a doing business as or a trade name. So it'd be, retail stores are us, or, wholesale stores are us. And those would be my 2 trade names. But ultimately they're all doing business underneath Corpus, Holdings LLC. So basically that's all your eggs are in one basket approach. So if you have one business that's very safe and another business that's a little bit more risk, you are ultimately putting all the assets up for potential collection. Even if it's the retail side is very safe, never have any liabilities, then those assets are potentially, going to be encumbered by or up for a creditor from the other businesses to try to collect on. So yes, you could have 10 trade names underneath my business, but ultimately we have one tax ID number, we have one bank account, and all those assets are in one basket. Another option would be literally you just set up a new company. You form a new limited liability company, you get a new tax ID number for your new business or your new location. So now you're going to have two sets of books, 2 checking accounts, you've doubled your work. This is very common with residential rental properties. You end up having 3 or 4 or 5 residential rental properties, and do you put them all in one company, or does each one have its own company separately? So you're starting to diversify your risk, and now you have 5 baskets with assets in it instead of 1 basket with all your assets. Another option that is new in Ohio with the new limited liability company law that came out last year is something called a series limited liability company. You have to put some magic language in the document that you file to create the company. You have to have some magic language in your operating agreement saying you want to be a series limited liability company. And then you could have one limited liability company with unlimited series, and each individual series acts as if it's a separate, distinct company or a limited liability company. And so as long as you properly segregate your assets and liabilities within that particular series, you could have one little limited liability company. Then series 1 would be your retail entity, series 2 would be your wholesale entity, and series 3 could be your consulting entity. And as long as you have your, internally with your QuickBooks, you're, properly segregating your assets and the liabilities in each individual series, the law is very clear that says the liabilities from one series do not, affect any other series or the company. So that's another way to segregate your assets, if that makes sense. I've had a bunch of clients that have residential rental properties in late 2022, converted their existing limited liability company to a series limited liability company, then dumped each individual residential rental property in its own series.
Yeah, I was just gonna.
It could work very well for a franchise. If you have multiple locations, you don't have to set up a new limited liability company with each location. So
that's so great. And I was just going to ask, can you convert your current LLC into that? And
you can.
Or would it be better to just start over? So
no, it all depends on prior liabilities, but no, you can convert an existing liability, a limited liability company into a series. You just need to amend the articles.
That's so great to know. And great that we have that. So if someone is thinking about starting a business, but they're not sure yet, and they want to grab, we want to protect our name, right? So can they register for a trade name or fictitious name? And then when they register the LLC, just move that? Do they have to dissolve the trade name, or does the LLC not, how can they make their trade name into an LLC or fictitious name?
Yeah,
I know fictitious name doesn't really protect your name.
Yeah, so if you if you believe that in the future you are going to set up a new company, but I'm not going to set this company up until the fourth quarter, but I don't want someone to take my name. So you have two options. One is you literally can reserve the name. The Ohio Secretary of State has a form that, without creating a company, without making a trade name filing, you can reserve that name. So no one else can use it. And then ultimately you would create your company with that name. Another option is if you don't have your company set up yet, you individually can make a trade name filing, and then then you would have a name. But the only issue with the trade name filing is you have to say I've started transacting business underneath that name, and you have to give a date. And certainly by marketing materials or business cards or business plans probably is sufficient. It's a very low threshold. But ultimately, you personally can get a trade name, and then when you go to set your company up in the fourth quarter, you would prepare your articles of organization, and along with that, Ohio Secretary of State has a form. It's called Consent for Use of Similar Name. Then you would give consent to your new company to use the exact same name. So you have two options in reserving your name before you actually need to set up your company. And then Ohio does have two different naming options. One is the trade name and one is a fictitious name. So the difference is that with a trade name, you are requesting exclusive use of that name in the state of Ohio. No one else is going to be able to use that exact same name in the state of Ohio. And you have to give a date of first use, and then that trade name filing is good for 5 years. You can renew it every 5 years. A fictitious name filing is a name that you are not requesting exclusive use in the state of Ohio. And it may be that you can't get exclusive use. So an example of this would be you're going to be a franchisee and you're going to be doing business underneath that franchisor's name. And so and there's 10 franchisees in the state of Ohio all doing business under the same name. So I don't have the right to do a trade name filing. So I do a fictitious name filing in that scenario. Okay. So I set up my limited liability company, Corpus Enterprises LLC, doing business as fictitious name filing Jimmy John's or whatever the franchise is. And so that would be the typical use of a fictitious name. Many people don't realize there's a difference, and they'll just click off and do a fictitious name filing because they don't know what the significance or ramification is. And that means you don't want exclusive use, and someone else can come in and make a trade name filing on your exact same name. Right. And now it's like you have two people with the exact same name doing business. And then the question would be can you even renew your fictitious name filing? Because now you have there's another trade name filing out there. I assume you could because you're the senior user, but it'd be weird.
This is amazing information. And this is why we always tell our clients, speak to a lawyer. Like, it's so important because these are things that, at the SBDC, we can't answer legal questions.
Yeah.
But these nuances that we don't know, right? Or most people don't know that there's a difference between the trade name and fictitious name, how the fictitious name really works, things like that. So it is so important to get some legal advice.
Yeah. And that's the thing, is you just don't know what you don't know.
Right.
And even if you do a little bit of research and you find out some information, you're probably just scratching the surface with what you're trying to find.
Exactly.
And then, and if you do find a document out there, it's the terms are someone else's deal, right? I mean, just because you find a document that says, redemption agreement, is that really the document that you need that meets your needs? Or it's someone else's, it's the terms from someone else's deal. And more than likely, their terms aren't the same as yours.
Sure.
Anyway.
Yeah. Are there any other tips or tricks that we need to know? Any other pieces of advice when creating, your single member LLC, when creating some of these things or thinking about some of these things that you'd like to share? Just some general information that our clients should know.
Yeah. I'm not anti-business partner or multi-member company, limited liability company, or multi-shareholder corporation. But you really need to go in carefully if you're going to have another owner in your company. Just because they're a friend, just because they're a worker, just because they're a hard worker, just because they do their job, doesn't mean they're partner worthy, right? I mean, it's, once someone else is in there, they're a minority owner, they have minority rights. You have to be careful how you make decisions. You need to make sure that you have the necessary information in your documents, that if they're no longer an employee, you get to redeem them automatically. Because I have a client that has all these shareholders are no longer employees and they're still shareholders. I'm like, this is nuts. Yeah. And so ultimately, that's probably my biggest caution, when I talk to clients that say they want to have another owner in a company that's not their spouse. I kind of consider spouses as still just like one member. Right. But if it's, kids, parents, brothers, sisters, you really have to go in, with your eyes wide open, because like I have a client, they are, went into business with their a sibling, and they hate each other. They haven't even opened yet. They haven't even signed a lease for their business yet, and they hate each other. And it's a different dynamic. That's generally my biggest caution is, and once you say, I want to make you a business partner, how do you unring that bell? Really weird to say, hey, I talked to my attorney. The attorney says, don't do it. We can do something else and get you profit distributions or something like that without you having to be a full-blown member. It's really hard to unring that bell once you mention, I'm going to be an owner. And you're like, yeah, no, you're not. My attorney said, don't do it. And you're like, now you've kind of soured your relationship. But sometimes you just have to rip off the Band-Aid and say, we're not doing it. Right.
We, unfortunately, we often see the aftermath. People have done this and then they come to us and say, help, what do I do? But, we have some tools that we can provide before you talk to a lawyer, just to start to map out that partnership agreement, think about things, before you talk to the person you might want to partner with. And then, obviously we can connect the client to you or another small business lawyer. But it's so important to really understand why you're getting into business with someone. And I just want to circle back real quick before we finish up on the spouse piece. So we, get a lot of people who are married and they want to start a business together, or the spouse is going to just do the books and some marketing, but not be full-time in the business. And they often, we both want to be on the LLC, but they don't have to, right? Like just one person can be on the LLC.
By no means do both spouses have to be on both be members of the limited liability company. I have sometimes they do that. They say, hey, I want my spouse to be involved on the ownership of the company, because for continuity purposes, if something ever happens to me. And if that's the only reason, then I'm generally like, well, that's not necessary, because we can make, have the management of the company be by a manager. And so that you as the member are the manager. And if anything happens to you, then we've already named your spouse as the successor manager that can step in and run the business. And on the back of the membership unit certificate or the stock certificate, if it's a corporation, we can do a transfer on death designation, so that sorry, my phone's ringing.
No,
We
that's
could do a
okay.
transfer on death designation, so that immediately upon your death, upon the member's death, the ownership interest in the company will directly and immediately go to the spouse without having to go through probate. And when I
Yeah,
tell that to people, they're like, oh, I guess they don't need my spouse on here, because that was sort of the only reason why. Now, if they're truly involved in the business, there's no harm in both spouses
sure.
being members, whether if there's a benefit for being minority owned, or female owned, or if the one of the spouses is a veteran, and they're actually, actively involved in the business to make them that designation a majority owner. But then you have to say, is it going to matter?
Right,
If I do, snow plowing for residential customers, does it really matter if I'm female owned? And you're going to say no. Now, if
right.
I do it for big commercial companies, maybe there's a benefit.
Sure.
But if it's so, I think there has to be a reason, why you would want it. Because if you're both owners of this company and I hit the proverbial bus and kill a bunch of people, then my ownership interest in the company is up for collection
Mhm.
by a plaintiff's attorney. And do I really want to expose potential ownership in the company to those liabilities? That may never happen, but they could for no
Right,
real reason.
right.
And so if they're actively involved in the business, I have no problem with, a spouse being an owner, but I don't do it just to do it.
Yeah, right, right. So, all right, the takeaway from all of this is protect yourself, talk to a small business lawyer. It's not always as simple as it may seem. There are these nuances or specific to your situation. So, that's where the SBDC can come in and help you and connect you to experts like Chris and provide other tools. So I really appreciate you taking the time to chat with me today about this. This is we get these questions a lot and we're not allowed to answer them. And so, and no, we're not, why would we, right? Like we don't, this is not our expertise. And so we want to, mitigate our clients' risk. And that's why we can refer them to individuals like yourself and small business owners like yourself. So I appreciate it. And I look forward to chatting again.
You're welcome. Thanks, Beth. You have a good one.
You too.
Bye.